yourself on mute.
I got
Hi.
it. Sorry.
Hi, this is Josh Blackman. I am the founder of the Harlan Institute, and it's my honor to bring you to the 2018-2019 Harlan Institute ConSource Virtual Supreme Court Competition. We are here today to argue the case of Timms versus Indiana. We are joined by a team from Creekview, Texas, Michaela Askew and Joanna Beyer, who I might add were our champions last year. They were the final round winners. And we are also joined by a team from Lake Oswego, Oregon, Maya Clydesdale and Danielle Need-Work. I am Josh Blackman. I will be the Chief Justice, I guess. And I'm here with my colleague, Julie Silverbrook, who's my Senior Associate Justice. Julie, how is everything going today?
Good. I'm excited for, I think this is our fourth preliminary round, and it's always fun to have the reigning champs back at this stage in the competition.
Very good. We'll begin with petitioners from Creekview. You'll have 15 minutes. You may begin whenever you're ready. And please take yourselves off mute. Yep, off mute.
To take them off mute.
Don't hear you quite yet.
They have to take them off themselves, I think.
Yeah, you have to demute yourself. Yeah, not yet. Still not yet.
Can you take them off mute?
Yeah. Yeah, click a little microphone icon. Okay, now we hear you. Okay, very good.
Now, start from the beginning because we didn't hear anything. Okay?
All right. Whenever ready. Yeah, 15 minutes. Thank you.
Mr. Chief Justice, and may it please the court. My name is Boyer.
And my name is Michaela Askew.
And we represent the petitioner, Mr. Tyson Timms, in today's case.
We are arguing the protections of the Eighth Amendment's excessive fines clause prevents the state of Indiana from seizing Mr. Timms' vehicle because, one, the excessive fines clause of the Eighth Amendment should be incorporated through the privileges and immunities clause of the 14th Amendment, and two, the due process clause also offers protections that prevent Indiana from placing unreasonable fines on Mr. Timms.
Would the court benefit from a brief recitation of the facts?
Please, thank you.
In the beginning of 2013, Mr. Tyson Timms became addicted to a prescribed pain medication until his prescription ran out and he subsequently turned to heroin. In May, a confidential police informant connected Mr. Timms to heroin and told police officers that he would be able to buy the drug from Mr. Timms, which led officers to set up 2 controlled drug buys.
In June 2013, the state charged Timms with 2 counts of dealing a controlled substance and 1 count conspiracy to commit theft. During the criminal court proceedings, a law firm acting on behalf of the state began filing a case to have Timms forfeit his vehicle. Timms then pled guilty to 1 of the felony dealing charges and a conspiracy to commit theft charge in exchange for the dismissal of the remaining charge. After accepting the plea deal, the trial court sentenced Timms to 6 years and had him pay fees and costs totaling to approximately $1,200. Austin, the United States, held that like the other 8th Amendment protections, which have long been understood to apply to states, the excessive fines clause prevents government from abusing its power to punish. And although the court's incorporation cases have typically been built upon the due process framework, the privileges and immunities clause provides an alternative path for holding the excessive fine clause applies to the states.
And counsel, if I can interrupt you, I think you're right that the precedents of this court going back for nearly a century relied on the due process clause to incorporate the rights. Why should we change course here and look to the privileges or immunities clause?
Your Honor, the privileges and immunities clause
Sorry, ignore that.
Better protections for the citizens, and if we continue to use due process when incorporating the excessive fines clause, it would then allow states to place unreasonable fines on their citizens.
But why would it be different if we choose due process or privileges immunities? Why would it make a difference to people of Indiana?
Your Honor, Horner versus Curry held that the state of Indiana has used excessive fines under their version of due process to consistently deny people of their property and even liberty through millions of dollars of fines, allowing them to continue this under their version of due process, which the state has discretion on controlling.
But why can't the council? Why can't we just impose the federal due process standard in Indiana that will be the same in all 50 states? In other words, what's wrong with using the due process clause here?
Your Honor, the due process clause allows, even applying the federal standard of the due process clause, allows the states to impose excessive fines as long as they give some semblance of procedural safeguards. However, like the other 8 rights secured in the first 8 amendments, the right to be free from excessive fines is a privilege and immunity of the citizens. And the District of Columbia versus Heller and McDonald versus City of Chicago has recognized that to apply the Privileges and Immunities Clause, a court merely should only discern what ordinary citizens at the time of the 14th Amendment's ratification would have understood the 14th Amendment to protect against.
So, Counselor, you cite you cite McDonald. Did the McDonald court rely on the Privileges or Immunities Clause?
No, Your Honor. However, in a concurrence, Thomas Justice recognized and considered the Privileges and Immunities Clause as a more direct path of protecting citizens' due process rights, especially rights that are expressly enumerated under the Constitution, by holding that ordinary citizens would have recognized the 14th Amendment as protecting, through the Privileges and Immunities Clause, enumerated rights and fundamental rights. And the right to be protected against excessive fines is both.
In addition to
being so Counselor, if I interrupt, but Justice Thomas's opinion was only a concurrence; it wasn't the majority. And in fact, the other 8 justices declined to rely on the Privileges or Immunities Clause. Why should we go down the route of Justice Thomas when everyone else in the court was okay with not going down that road?
Your Honor, we should use the rationale of Justice Thomas because the situation and issue in today's case is more uniquely prone to abuse than the situation in McDonald versus City of Chicago.
Why? Why?
Your Honor, because as held in Browning versus Kelco, the state of Indiana is competing with their impulse to raise royal revenue and their duty to act fairly and justly, and have shown that that their sanctions are still prone to abuse, because Indiana has even gone so far as to use sanctions to deprive people of their homes. Since 2016, Your Honor, code law enforcement officers in Charleston and Indiana have used their version of due process to flood low-income neighborhoods with millions of dollars in fines to help a developer buy property in their neighborhood. And, Your Honor, allowing the states to incorporate the excessive fines clause under the due process clause would allow the states to continue to impose any fines they wish under the guise of procedural safeguards.
But why? Right. So you've said that. So explain to me why a proper interpretation of the substantive due process clause leads to us allowing things happening in Indiana, and I can use the example of Charleston, that you believe are unlawful and unconstitutional.
Because, Your Honor, the due process clause gives more discretion to the governments themselves in what does constitute procedural safeguards, although there are several federal standards that provide guidelines.
And what are you basing your understanding of that the due process clause is more permissive? What is that based on?
Your Honor, that is based on the finding of several cases such as Hall versus Florida and Browning versus Kelco.
Okay, and what are those cases? And tell me about the outcomes in those cases.
Your Honor, in those cases, the courts held that the excessive fines clause is applicable to the state, even in cases of civil in rem forfeiture, through various methods of incorporation, and some have included to hold that the state's due process methods have not adequately protected a citizen's rights.
But if the states, the processes which they are using are not adequate, right? So under an application of the due process clause, the federal due process clause, to the states in this context, right? Are we not saying that in those cases the states are not doing things properly, right? Their efforts are unconstitutional, I'm having a lot of difficulty in understanding your argument as to why using substantive due process is somehow inadequate. Just flesh that out for me, and then tell me why privileges or immunities is better.
Well, Your Honor, when considering the privileges and immunities versus the due process clause, as early as the Slaughterhouse cases, it's been recognized that the privileges and immunities offers more protections to citizens than the due process clause itself. So,
is that what Slaughterhouse says?
Your Honor, Slaughterhouse holds that the privileges and immunities protects the rights of federal citizenship, which applies a more federal and scrutinizing standard than the due process right. And furthermore, Your Honor, even if this court
were to look past the compelling reasons to incorporate excessive fines under the privileges and immunities clause, the due process clause also offers protections that would restrict the state of Indiana from using civil forfeiture to place an unreasonable fine on Mr. Timms.
Counselor, let me ask a question. Let's try and maybe get back to the core of the issue here. How should this court go about deciding what is a privilege or immunity protected by the 14th Amendment? What can we look to?
Your Honor, in the Slaughterhouse cases, the court held that the privileges and immunities protects the privileges and immunities of virtually federal citizenship. However, the courts declined to state what in fact does constitute federal citizenship. However, in District of Columbia versus Heller and analyzed by Justice Thomas in McDonald versus City of Chicago, those justices analyzed the 14th Amendment and held that ordinary citizens would have understood the privileges and immunities clause to protect constitutionally enumerated rights. And the excessive fines clause is constitutionally enumerated under the 8th Amendment.
Can you point us to some primary sources or historical arguments about why that's the case?
Your Honor, historically, states have used their power of excessive fines to their power of fining to place excessive fines on their citizens. And as early as 2015, Indiana has used their fines to deny people liberty and property. Furthermore, as early as the Magna Carta, people have recognized that a person has a fundamental right to be free from excessive fines. And furthermore, in the Virginia Bill of Rights, Virginia themselves recognized that citizens should be protected from excessive fines by including an excessive fines clause in their own Bill of Rights.
Counselor, would you have us overrule the Slaughterhouse case?
No, Your Honor. In fact, the Slaughterhouse case can be read in conjunction to the finding in today's case, because the Slaughterhouse case did not state that the privileges and immunities clause should never be applied, but that they should be applied when dealing with issues of federal citizenship and federal rights. And in today's case, because excessive fines is both fundamental, constitutionally enumerated, and presents a uniquely abusive situation, the excessive fines clause should be read as a federal right should be granted.
Would we have to overrule any cases to get to your preferred result?
Well, Your Honor, Your Honor, District of Columbia versus Heller held that ordinary citizens at the time of the Fourth Amendment's ratification would have understood the clause to protect constitutionally enumerated rights.
Well, DC v. Heller didn't have to do with the Fourth Amendment, though, did it?
No, Your Honor. However, looking and applying it to a more broad issue, the privileges and immunities would provide adequate protections for this uniquely and dangerous situation of excessive fines.
What about Cruikshank? United States versus Cruikshank.
Your Honor, I'm not familiar with that case.
Okay, very good. Okay, you have about 2 minutes left. You can continue.
And Your Honor, even if this court chooses not to apply the privileges and immunities clause in today's case, considering the deeply rooted tradition of protecting against excessive fines, it is clear that Mr. Timms is guaranteed the process of law. However, the state of Indiana has used the civil court system to circumvent the law and deny Mr. Timms due process rights in two crucial ways. By denying him a proper burden of proof and by denying him access to a jury. First, when dealing with an issue brought before a criminal court, the beyond a reasonable doubt standard is a requirement of due process, as held by Victor versus Nebraska. That same standard must also apply to civil court cases brought forth by agents of the state or on behalf of the state, as the private law firm in today's case did, as recognized by City of Chicago versus Chicago Burlington.
This means that a private law firm acting on behalf of the state in a civil trial must be held to the same burden of proof as the state in a criminal trial, allowing states to use...
About 1 minute left, counsel, if you want to wrap up.
And Your Honor, furthermore, the state of Indiana has denied Mr. Timms a right to trial, a right to a forfeiture jury trial, which has been recognized as a right under United States versus 1, and have placed on him a fine that is disproportionate to his crime because it is 4 times larger than the maximum criminal fine. And Your Honor, the Eighth Amendment excessive fines clause should be incorporated through the privileges and immunities clause of the 14th Amendment because the privileges and immunities clause creates better protections for citizens from the states that abuse their power to punish. And the Eighth Amendment precedent has consistently recognized that the right to be free from excessive fines should be protected.
Even viewing excessive fines under due process clause, Mr. Timms should still...
Okay, counsel, you can finish your sentence.
Okay,
very good.
You can finish your sentence if you'd like to.
It is for these reasons that we pray that this court protects citizens' Eighth Amendment rights and do so by reversing the lower court and ruling in favor of the petitioner, Mr. Tyson Timms.
Okay, thank you.
Thank you, Rachel. If you could put yourself on mute in Texas, and the team in Oregon, you can take yourself off mute. Okay, very good. And you can begin whenever you're ready. You have 15 minutes.
May it please the court that I, Danielle Mead-Worth, and my co-counsel, Maya Clydesdale, represent the respondent today in the case of Timms v. State of Indiana. The question we are all faced with is whether the Eighth Amendment excessive fines clause should be incorporated through the due process clause of the 14th Amendment or the privileges or immunities clause of the 14th Amendment. Allow me to start with a brief summary of facts for the court. In June 2013, the state of Indiana charged Tyson Timms with 2 counts of dealing a controlled substance and 1 count of conspiracy to commit theft. In 2015, Timms pleaded guilty to 1 count of felony dealing and 1 count of felony conspiracy to commit theft, and in exchange, the state dismissed the remaining charge. In addition to a sentence of 6 years, Timms was charged with a variety of fines totaling $1,203. Let me make it clear that the trial court observed that the maximum statutory fine for Timms' Class B felony was $10,000 on the day he was arrested. Many months after bringing criminal charges, a private law firm filed a civil case against Timms to force him to forfeit his vehicle on behalf of the state. Purchased by Timms in January 2013, the value of the Land Rover was about $42,000. This amount is well above the maximum statutory fine of $10,000 and would be restricted under the excessive fines clause of the 14th Amendment once incorporated into the states through due process. The first question you may have is if this civil forfeiture would even qualify as a fine in order to result in an excessive fine.
Counselor, if I could just interrupt you, I think the major prompt we have, the major issue we want to decide, is whether this court should incorporate the Eighth Amendment under the Due Process Clause, the Privilege and Immunity Clause. So can you maybe speak about that issue?
Yes. If there is an excessive fine for this case, this would be a protection that would be necessary to be extended to Mr. Timms if it was incorporated through due process. The Due Process Clause of the 14th Amendment allows the excessive fines clause to be incorporated as decided first in the slaughterhouse cases. In 1873, this was the first time that the court was called upon to interpret the 14th Amendment, and therefore the court had to set the standard for how it would be used in the future. In a 5-4 decision, the court decided that due process would be the standard used to incorporate amendments or parts of amendments into the state. This was used for the first time in Gitlow v. New York in 1925 to incorporate part of the First Amendment. In the 5-4 decision, the court also decided that they would limit the Privileges or Immunities Clause for the states. The Privileges and Immunities Clause would still allow the Bill of Rights to be applied to federal citizens, but there is an important distinction between federal citizens and state citizens. In Section 1 of the 14th Amendment, it says, quote, "All persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside." This is a written distinction between citizens of the state and the United States, and there is also a distinction between the two for the protection of the laws. This claim is further supported by Justice Miller when he writes in the majority opinion, quote, "It is quite clear then that there is a citizenship of the United States and a citizenship of the state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual."
So, counsel, was the Slaughterhouse case correctly decided?
Can you say that again, sir?
Was the Slaughterhouse case correctly decided?
Yes, it was correctly decided because in another part of the 14th Amendment, it reads that any law which shall abridge the privileges or immunities of citizens of the United States, and this specifically shows that the privileges and immunities applies to federal citizens, whereas if you want to protect the right of just the states, it says, "Nor shall any state, not the United States, deprive any person of life, liberty, or property without due process of law."
Well, I know it says it, but how do you know if Slaughterhouse was correct or not? Just what was Slaughterhouse correct as an original matter? Was that a correct interpretation of the 14th Amendment?
Yes, and this has been shown time and time again when in cases in the past that have used this standard, and it has been looked at again and again in.
What are those cases, counselor?
Those cases are for the First Amendment, the freedom of speech was incorporated using due process in Gitlow.
No, I get that. No, I know the court has used due process in a number of cases. My question to you is something different. How do we know that Slaughterhouse was correctly decided? I mean, what evidence is saying that Slaughterhouse was correct?
Well, we could look to a textualist interpretation and specifically look at the Magna Carta, which refers to due process as sort of the law of the land. And a quote from chapter 39 of this is that no free person shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so except by the lawful judgment of his equals or by the law of the land.
No, I get that, and I get that the due process clause may be correct, but I'm asking a very simple question. How do we know that Slaughterhouse was correctly decided? What evidence we have that Slaughterhouse was a correct interpretation of the Constitution?
I think the evidence that we have is that it's an issue dealing with both federally and at a state level. And due process protects against both of those, whereas privileges and immunities is only protecting against citizens at a federal level.
You're not answering my question, but I'll
Blackman, I'm going to push back against you on your question, which is that we don't need to answer that question in order to dispose of that case, do we?
Correct.
Okay. So keeping that in mind, why don't you continue to take us through the due process analysis?
Later in the 14th Amendment, as I said, it shows the difference between privileges and immunities applying rights only to federal citizens and due process being used to protect the rights of state citizens. And privileges and immunities does not automatically apply certain rights to the states. The real process of due process must be used, and it is only once an amendment or part of an amendment is incorporated through due process individually that it is then incorporated and applied to the state, not automatically from the privileges and immunities, as the courts have previously done with the First, Second, Fourth, and Sixth Amendments, as well as parts of the Fifth and Eighth Amendments. In the case of City of New York v. Mills, the Commerce Clause could not be used to prosecute the defendant, who was a state citizen, because it had not yet been incorporated through due process. In order for a right to even be incorporated through due process, the founders intended a right to be incorporated once it was deemed necessary for incorporation. In Duncan v. Louisiana in 1968, Justice White defined this standard by explaining that the 14th Amendment only incorporates certain fundamental provisions but not other fundamental provisions, which was named the selective incorporation theory. Due process is a procedural, not a substantive right, and it is a process that must be used on a clause-by-clause basis if there is a need to decide whether an amendment or part of an amendment needs to be incorporated. The standard emerged when Justice Benjamin Cardozo held that the Due Process Clause protected only those rights that were of, quote, of the very essence of a scheme of ordered liberty, in Taco v. Connecticut in 1937. On the other hand, rights that are not fundamental to the scheme of ordered liberty, such as the right to a jury trial in a civil case involving more than $20, were not made applicable to the states through due process. To be fundamental to the American scheme of justice means that a right needs to be a vital need for each American citizen to have in order to be treated fairly in a trial in the United States justice system. And this was further upheld in the case of Duncan v. Louisiana, where the opinion wrote that, quote, the rights must be fundamental to the American scheme of justice, further upholding this standard. This has been used in cases such as District or McDonald v. Chicago in 2010, where the judges found the Second Amendment right to be, quote, among those fundamental rights necessary to our system of ordered liberty.
Can you tell me, Counselor from McDonald, let's talk about Justice Thomas' concurring opinion for a minute. You think that Justice Thomas's concurring opinion was wrong?
We don't believe that it's like, it's one way to look at the question, but we think that the majority opinion was the most correct and was the most applicable to this situation and protected the most rights, whereas the privileges and immunities is a little insecure, if you might, and because it doesn't apply directly to citizens of multiple states.
And is that a reason not to rely on privileges or immunities?
Yes, I think so, because it brings up the question later on with future cases of does privileges and immunities really provide enough protection, and it's not enough compared to due process, which provide protections for citizens, like all citizens of federal government, but then citizens of individual states.
Okay, you can continue.
Now that once this has been established, looking at the excessive fines clause specifically for this case, this clause was written to protect citizens from having to pay excessive fines as a punishment for a crime. The fine of the car was about 4 times the amount of the maximum statutory fine for the crime committed by the defendant, $10,000, and this is a protection absolutely necessary to protect citizens of each individual state as well. Even England's Magna Carta required that financial penalties, quote, be proportioned to the wrong. As discussed in United States v. United Mine Workers, the defendant's economic status and position must also be considered when deciding what is excessive. Seeing how the car is Mr. Tim's only mode of transportation, and he is not an extremely well-off man, an amount 4 times the amount of the maximum statutory fine is, quote, grossly disproportionate to the gravity of the defendant's offense, the standard defined in United States v. Bajikaju. The right to protection against excessive fines is therefore fundamental to the American scheme of ordered liberty. Allow me now to look at the precedent, which is the third main argument that we have of why it should be incorporated into due process. Established as the standard of incorporation, due process has been used each and every time a federal right was deemed fundamental to the state into the American scheme of ordered liberty. Due process incorporated freedom of speech in Gitlow v. New York in 1925, freedom of press in Muir v. Minnesota in 1931, freedom of assembly in Dijon v. Oregon in 1937, establishment of religion in Everson v. Board of Education, the right to bear arms in McDonald v. Chicago, the freedom from unreasonable searches and seizures in Mount v. Ohio, and the requirements for a warrant in Aguilar v. Texas in 1964. Due process also incorporated the Sixth Amendment right to a trial, jury, and testimony, and finally aspects of the Eighth Amendment in case of Robinson v. California in 1962, which incorporated protection against cruel and unusual punishment. Every single one of these fundamental rights was incorporated using the due process standard establishment in the slaughterhouse cases in 1873. Based on stare decisis, it is important that the court continue to make decisions based on precedent. Precedent helps judges to make decisions that are consistent and make sure that the rules are clear and followed. Justice Breyer elaborates on the significance of precedent, the significance precedent has on the structure of our nation when he says, quote, "Every one of us understands that if you change the law too often, even when it was wrong before, people cannot live their lives. They can't plan how to live, they can't plan their society. In order for the courts to remain in a stable position where their decisions are clear and consistent, precedent must be followed, as due process is the established standard and the only standard previously used to incorporate rights to the states."
Okay, but a minute left, Counselor.
Okay. We are faced with the question today of how to incorporate a right into the states, through due process or through privileges and immunities. This was the same question the judges faced in the slaughterhouse cases when interpreting the words of the 14th Amendment for the first time. Those judges set a precise standard with a clear distinction between a state and federal citizen, defining the privileges and immunities clause as a way to protect federal rights, and defining the due process clause as the procedural right to be used to protect citizens of the state from being denied any fundamental rights. These rights protected for state citizens must be fundamental to the scheme of ordered liberty, the standard defined in Palka v. Connecticut. There has been no drastic change in this, and the question remains the same. So why are we questioning the precedent and interpretation of this clause when the standard has already been set?
Okay. Time. Perfect timing. Good job.
Yeah.
Okay. We have now 5 minutes from the respondents. Please proceed on mute. And if in preview, please put yourself off mute.
Great.
And you have 5 minutes.
Thank you, Your Honor. May it please the court. Positions made by the opposing counsel. The opposing counsel assumes that the distinction in today's case between state and federal citizenship. But, Your Honor, the true question is of rights. And when a right is federal, even Slaughterhouse recognizes that privileges and immunities is the appropriate method of incorporation. And the right in today's case is federal because it is enumerated as recognized by District of Columbia versus Harlan.
Counselor, I want to go back to actually something that your colleagues on the other side said, which is basically their argument is you've incorporated via substantive due process all this time. Why upset the apple cart? So why upset the apple cart? What is it about privileges or immunities that to you is it is the correct path? So we should diverge from our precedent using the substantive due process clause to incorporate federal rights against the state.
Well, Your Honor, this court should diverge privileges and immunities instead of due process, because unlike some of the other rights brought up by the opposing counsel, such as the Fourth Amendment right to be free from searches and seizures and the First Amendment right, the Eighth Amendment does not allow a government to place excessive fines on a citizen at all, regardless of if the state offers some procedural safeguards, whereas other rights, such as the First Amendment, can be restricted when a citizen has been given such procedural safeguards. And in today's case, Your Honor...
But Counselor, I sort of understand what you're saying, but isn't it true that the government can fine people, they just can't fine people in an excessive way?
Yes, Your Honor. And however, by incorporating the excessive fines clause under due process instead of privileges and immunities, this court is granting the states the ability to apply fines on citizens as long as they offer certain procedural safeguards. And those safeguards would not prevent the fines in today's case from being excessive, because the due process merely ensures that procedural guidelines have been met, not the substantive rights and protections of the citizens. The rights of the citizens, especially when dealing with rights such as the excessive fines clause, are better addressed using the privileges and immunities clause.
And Counselor, let's talk about stare decisis a little bit. So how do you understand the concept of stare decisis?
Your Honor, the concept of stare decisis is that the court must follow the precedent set before by the previous cases.
And if we follow stare decisis, what should we do in this case then?
Your Honor, we should follow stare decisis and follow the holding of the slaughterhouse cases, which recognizes that when a right is federal, instead of a right being a method of a state citizenship, privileges and immunities is the appropriate method. However, in the slaughterhouse case, the court found that the issue at bar was not based on federal citizenship rights. However, in today's case, the right is explicitly enumerated and is prone to governmental abuse and is therefore a federal right.
But we're not just talking about slaughterhouse. We're talking about over 100 years of precedents in which the courts rely on the due process clause. What do we do with those cases? And you have about a minute left.
Yes, Your Honor. And those ruling that the privileges and immunities clause is the proper method of interpretation would not deviate from those courts' rulings, because of issues between the excessive fines clause and the issues brought up before those courts today. Is the excessive fines clause, because the due process clause may be an appropriate method of interpretation for some issues, however, it is not appropriate for the excessive fines clause. And finally, Your Honor, even if this court chooses to accept every argument made by the opposing counsel, even that privileges and immunities should not, the opposing counsels themselves concede that the fine placed on Mr. Timms was excessive, which means that the action done by the state of Indiana is unconstitutional, and the court would therefore should rule to protect citizens' Eighth Amendment rights, and to do so by ruling of the petitioner, Mr. Tyson Timms. And Your Honor, it is for these cases that we once again pray this court reverse the lower court's ruling and rule in favor of Mr. Tyson Timms. Thank you, Your Honor.
Okay, thank you so much. With 5 seconds to go. 4, 3, 2, 1. Good, very good. Okay, and we now have 5 minutes from the respondents. You can begin whenever you're ready.
May it please the court. Due process is overt and consistent, whereas privileges and immunities is vague and contingent. Whether or not the court decides to apply the excessive fines clause by due process or privileges and immunities is relevant to citizens of the United States and citizens of each state. Mr. Timms' case identifies the importance of incorporating the Bill of Rights to the states to ensure no citizen is forced to pay a fine that is disproportionate to their crime. The case of Harlan v. Michigan, whose majority opinion was written by Justice Scalia, highlights the problem of not incorporating the excessive fine clause to the states. Fines and forfeitures are a source of revenue for the state. And currently, without the incorporation of the excessive fine clause, fines imposed by the state are disproportionate to the severity of the crime, are constitutional. The concerns with the excessive fine clause date back to the Magna Carta in 1215. During the 13th century, there was an extensive amount of discontent and criticism towards the imposition of excessive fines. For example, using excessive fines to diminish political opponents' silent speech and to maintain control over those who could not afford to pay the fines. This case becomes a crucial issue of incorporation to ensure no state abuses its power over its citizens. Due process of law is a standard the court should use when incorporating rights to the states because it is the most clearly applicable and fundamentally fair. After all, in the 14th Amendment, the Due Process Clause states explicitly that no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Whereas the privileges and immunities applies to citizens of the United States and does not speak to those of citizens of several states. Through a textualist interpretation, this right should be incorporated to the states through due process because of the words clearly stated in the Constitution. As the petitioner argued earlier, that from an originalist point of view, the first 8 amendments are privileges and immunities intended by the founders. However, since the Constitution was written before the Bill of Rights, wouldn't the words of the Constitution be the most original interpretation? Justice Miller, who wrote the majority opinion in the slaughterhouse cases, expresses the insecurity that incorporation through the privileges and immunities clause would create. He expands on this when he says, the constitutional provisions there alluded to did not create those rights which it called privileges and immunities of the citizens of the state. It threw around them, and in that clause, no security for the citizen of the state in which they were claimed or exercised, nor did it profess to control the power of the state government over the rights of its own citizens.
Additionally, I would like to clear up what we said about if the fine would be excessive or not. I said that the fine would be considered excessive if and only if it was incorporated into the state's first.
Finally, it is essential that the court continues to follow precedent. While there are instances where setting new precedent is important, for example, if the standard has evolved and changed, I think that could be looked at with the 4th Amendment, with privacy rights, and if those rights now, because so many people have technology, if those rights should be extended to cover technology, that would be an example of when precedent should be changed. However, in this case, we believe that precedent should stay consistent and stay the same because the words and the text are still the same. We allow our court system to set laws and create the guidelines that sustain our society. Stare decisis and the establishment of precedent is what holds our courts accountable. Since the 5-4 decision in the slaughterhouse case, due process has been the standard used when incorporating rights to apply to the state. Most of the Bill of Rights has been incorporated against the states through the 14th Amendment via due process.
Okay, about a minute left, Council. You want to wrap up?
In fact, the 8th Amendment cruel and unusual punishment clause and excessive bail clause were both included in the states using due process. Thus, it's important that we maintain precedent and stay consistent with our ruling, not just within an amendment, but also in the Bill of Rights as a whole.
Okay. Thank you very much.
Yeah.
Thank you. This will bring to a close the round. I would like to thank both teams. You did a wonderful job. We are very proud of you. Every year we seem to get better and better submissions. We will probably make our decision the next week or so. Thank you all so much. This was really wonderful. Julie?
Yeah. Congratulations on a job well done. We know that this is challenging. We ask a lot of really hard questions, and the more questions you get, the better. Thank you for being responsive to them. Be proud of what you did and go enjoy your Saturdays. And like Josh said, we expect to make a decision early next week on who will be coming to the championship round in Washington.
Thank you.
Thanks so much.
Thank you all so much. And with that, course adjourned. Thank you.
Thank you.